Morning, everybody. My name is Ben Theron. I'm the Chief Executive Officer for the Whistleblower House. Just some background to the Whistleblower House for anybody who's not been part of our webinar before. We were started by three whistleblowers. It was Ivan Pillay, Liesel Groenewald, and Bianca Goodson. And the reason for them starting the business was when they became whistleblowers, they were looking around and they were trying to find support for what they needed. And they identified a few areas and they registered the Whistleblower House. And myself and Cynthia was brought on board in October 2021. And we opened our doors in February 22nd, 2022. The service we offer is based on the needs analysis done by the three people. And those were legal services primarily. Hopefully people come to us before they blow the whistle so they can get assistance. But more often than not, afterwards, they blow the whistle, they land up in trouble, they get fired, they get disciplined, then they need legal advice. So that is the priority number one. Second one that we offer is psychological support. People suffer because they've lost their jobs, they have no income, their families suffer, they have stress-related issues, etc. We do financial support because people lose their jobs, and we have a stipend, 15,000 Rand a month over 6 months, purely just to survive. It's not intended to make people rich, but just to survive. And then safety and security. What we will be doing in the session is covering those individual items one by one, and we will be starting off with legal services with one of our esteemed panelists. MLB is the company's name, and Svi Brivik will be running with us. That will be followed with psychological support, Siandra Msibi, sterling work by our panel, and she represents the panel. So when she speaks at a principal and a conceptual level, not only on behalf of herself, but the services we offer. I think we've got 12 psychologists on board. Cynthia will talk about the financial stipend, the process, what it's intended for, etc. And then I'll finish off with safety and security. Svi, would you take over and start talking? Thank you.
Good morning, everybody, and thanks so much, Ben, for that introduction. My name is Svi Brivik, as Ben has said, from Malcolm Lyons and Brivik Incorporated, and I've had the pleasure and also the honor of working closely with the Whistleblower House since its inception. I'm an attorney, so that's why legal services is where I would fit in. And the purpose for today's presentation is just to introduce you to the processes that the Whistleblower House provides insofar as legal services are provided. So for this particular presentation, I'm not going to be dwelling too much on the substance of what a whistleblower is, although I will touch on it because I do think it's important. What is whistleblowing and what is an occupational detriment? Because I think these are all extremely important in understanding at which point the Whistleblower House provides assistance and what assistance it can provide insofar as legal services are concerned. So just to go back to the beginning, and everybody's heard the term whistleblowing, and most people, I'm sure, on this call or this webinar have heard of the Protected Disclosure legislation or the Act. And the understanding, of course, is that it's there to protect whistleblowers. So whistleblowers are those who disclose information about any wrongdoing in the workplace, and it can be both in the public and in the private sector. The purpose for whistleblowing is to promote integrity, accountability, discourage corruption. And we know that that is a scourge in our current economy and politically. And so we need to encourage whistleblowers to come forward. We need to encourage them to provide information to the correct authorities and in the correct manner, so that the information is usable by the relevant authorities. So it might be National Prosecuting Authority, it may be SAPS, it may be intergovernment organizations which are responsibility for accounting and auditing and financial management. So for those purposes, there are different types of legislation or different authorities. And if we have some time, we can go through that towards the end of my presentation. Ultimately, what a whistleblower is concerned about is abuse of resources or criminal wrongdoing within an operation in which he or she is employed. But in order to be protected in terms of the legislation, the information must be presented in a certain way. And I think Ben makes a very good point in the introduction when he says, hopefully, people approach the Whistleblower House before they choose to make the disclosure, because that is where the Whistleblower House can provide probably its most important input in advising people how that should be done and to whom. Because the Act does specify, and in that respect, it lists a number of factors, and the factors are peremptory, what needs to happen and how it needs to happen. And in order to avoid what is referred to as an occupational detriment, the whistleblowing needs to be done in the correct manner. So let's just look at what needs to happen, or how the whistleblowing should take place. So the Act says it should be done in good faith. In other words, there shouldn't be any element of malice or malafides. It's not for personal gain either, but that's where one whistleblower believes that there's a wrongdoing, and that by bringing it forward, he or she is doing it for the better good. Obviously, there must be a correct procedure, and in most large organizations, certainly in most government departments, there is a whistleblowing or protected disclosure policy with a person who's nominated, and a process within how that is to be done and to whom, and what the obligation then is on the employer insofar as investigation and reaction is. And the whistleblowing must also be done without having committed a criminal offense. That's often a tricky one insofar as obtaining information, documentation for presentation. But the information must be readily available or available to the employee so that they can present it and forward it on to the relevant authorities. And then it's important that it's done to the right person, to the right authority. So when we say doing it in good faith, we mean honestly, sincerely, and without the intention to deceive. What is important also is that the reason why the Whistleblower House has set itself up, or one of its purposes, is to protect those employees once they've made protected disclosures from what we refer to as occupational detriments, and that you'll find set out in the legislation. The most common occupational detriment or harm as a consequence of blowing a whistle would, of course, be a termination of employment. So you would have that person's employment terminated, and that usually it's not on the basis of having made a disclosure, but it's because of some other reason. Maybe it's a performance issue, maybe it's misconduct, maybe it's a disguised retrenchment. The question to be determined is, what is the proximate cause? What is the nearest, most relevant cause to the termination taking place? And if it's near in time to the occupational detriment being made, well, then that is the most likely cause. So I just want to take a step back here, and you may ask, why am I speaking on it, and what makes me an authority on it? I can refer to the case of Grieve versus Donnell, and I can use the names. It's a reported decision. It was the leading news story at one point at the SABC. It was a story about an employee who was working for Donnell, who had put together a dossier of wrongdoing within this parastatal organization, and had presented it to his direct supervisor, who then passed it on up the line. As a direct consequence of that, he was issued with a notice setting out numerous charges of disciplinary misconduct, with the aim of terminating his employment before his report or the dossier that he had prepared had been made public. We then were the first to use that legislation here in Cape Town in the Labour Court. We went to court with an urgent application to prevent the disciplinary hearing from taking place. And we had to argue those points about whether a disclosure had been made, was it made in good faith, was it made correctly, ultimately to establish that a protected disclosure had been made, and then link that to what we argued was the occupational detriment, which was the notice calling for his disciplinary hearing. So that was a 2003 decision, and it's often referred to in various papers. You'll see it's published on most legal websites. Most attorneys' firms refer to that decision, and we managed to prevent the disciplinary hearing from taking place, and also from his employment from being terminated. So that's my background, where I and our firm assisted in one of the first protected disclosure matters to be heard by the courts and the testing of the legislation. But I want to go back to the occupational detriment. There are other types of occupational detriment. Transfers. demotions or refusal to transfer, disadvantageous working conditions. All of those can be considered occupational detriments, and all of those, if proximate in time to the disclosure having been made, are likely as a result thereof. So they would entitle the whistleblower to the protection of the legislation. There are more than one type of legislation to assist protected whistleblowers. We focus mainly on the protected disclosure legislation, but we need to take it up a few steps up. Obviously, the Constitution, being the Supreme Court, being supreme law of the land, provides protection in the form of Section 16(1), which is a freedom of expression. You then have the Labor Relations Act, and there you have Section 187, which says that you are protected from an automatically unfair dismissal, a special type of dismissal, of which being terminated or having your employment terminated rather for making a particular disclosure is one. It also entitles you to double the ordinary compensation, which is 24 months as a maximum. There's certain regulation in the Companies Act, which one must be aware of, because that regulates protection of whistleblowers within profit and non-profit organizations as well. There's the Protection Against Harassment Act, PAHA, which is also relevant because Section 2 prevents harassment if you make a protected disclosure as well. There's the Prevention and Combating of Corrupt Activities, and then finally, our Protected Disclosures Act. But even with all this legislation and the protections which are afforded, there are still some gaps or shortfalls which the law hasn't yet provided for. And that's where the Whistleblower House comes in, and that's where it fills that gap. So what are some of those gaps in the current legislative framework? Well, the first is there's lack of legal assistance. None of these acts make provision for a Section 9 institution, for instance, such as the Human Rights Commission or the Public Protector's Office, to assist whistleblowers with their litigation. There's inadequate trauma counseling. So they don't make provision for trauma counseling because, as you may well guess, and I'm sure our next speaker will elaborate on, making a protected disclosure is extremely stressful, both for the person making the disclosure and for their families. And we've read about that in the newspapers. We've seen that on carte blanche, for instance. Where is that protection? That's not in the legislation. There are no rewards or compensation for making the protected disclosure. Now, you may think, I've just said that it must be not for gain and it must be for good faith. But in most jurisdictions outside of South Africa, if a protected disclosure proves to be bona fide and correct, and there's a recovery for, say, the fiscus or a government body or even a private body, then there's a percentage of that which is paid to the person making the disclosure. And there's nothing untoward about that because of the occupational detriment, because of the devastating career consequences which the person is going to suffer, there should be some reward. Otherwise, what they're left with is perhaps having done the right thing, but then not being able to provide for their families. So again, the Whistleblower House's stipend for that period of 6 months is critical for that period of time and to assist the whistleblower. There's also lack of immunity for the whistleblower. So I've said that the information must be obtained without committing a crime. But sometimes it's a fine line between obtaining the information for the correct reasons, ultimately, but the manner in which they're obtained, but without the protection, where would the whistleblower's incentive fall? Obviously, self-preservation is key here. So there must be some guarantee from criminal or civil proceedings. Of course, that's all provided that the disclosure is made in good faith, and it's all provided that it's proven to be, in fact, a protected disclosure. There's lack of public recognition for those who want it or who need it, but bearing in mind the significant contributions that these persons make towards our society, the reduction in corruption, ensuring that there's no leakage from government organization, perhaps there should be some public recognition for the act of bravery, which it really is, for what they've done. And again, there's no government dedicated institution to oversee the implementation of the legislation. And those are all gaps which the Whistleblower House seeks to fulfill by providing financial support, emotional support, and ultimately legal support. So just to talk through the process of how the Whistleblower House goes about it. The team, together with our input, have spent a considerable amount of time preparing and uploading a questionnaire or intake form where we believe that we've set out sufficiently what is required. So first of all, who the employer is, and that's important because there are a number of legal firms which are on the panel, and we need to ensure that there's no conflict of interest when the Whistleblower House refers this inquiry on. That's also to ensure that there's anonymity. So there is an agreement between the Whistleblower House and ourselves that we're not going to disclose the details of the inquiry, the person's making the inquiry. That all changes when matters become public, and anytime you issue documentation, be it at the CCMA or outside of the Labour Court, then these become public documents. But whilst we are assessing the inquiry and whilst we're considering documentation information, that process is completely anonymous and remains confidential. As Ben has said, preferably before the disclosure is made would be a good time to approach the Whistleblower House so they can refer that person on to one of the attorneys on its panel, because they would be able to guide the whistleblower by asking questions such as, who is the employer? Is there policy in place? How did you obtain the information? Who do you intend to make this disclosure to, etc. It also then assists us in preparing for whether there will be an occupational detriment, so that we can already lay down the groundwork to protect the employee from the consequent action which an employer may or may not take against that whistleblower. When we consider the form, we need to consider whether the person is still in employment or out of employment. And very often we get inquiries where a person has been out of employment and the period of where they've been out of employment is considerable. So it's important to just bear in mind the timelines which are in place. If a person's employment has been terminated, they would ordinarily have 30 days within which to refer this matter to the CCMA, which is a port of first call in all of these matters for a conciliation. Often if we get the inquiry a year, 2, 3 years down the line, it's very difficult to argue for condonation of such an extensive lateness for a referral. From the conciliation, we take the matter then through to the Labour Court. Why the Labour Court and not an arbitration at a bargaining council, if a bargaining council is relevant, or the CCMA? The reason is that these are considered to be automatically unfair dismissal. And you'll recall I mentioned Section 187(1)(f) of the Labour Relations Act, and as such, all to be determined by a judge rather than a commissioner or an arbitrator. And that means drafting the papers accordingly and presenting them to court, waiting to receive a statement of response from the employer if the one is served or provided, and then arguing the matter from preparing the trial and arguing the matter, leading the evidence and arguing the matter from there. The Whistleblower House commitment, once they've elected to assist a person, is from the initial inquiry being made and taken on up to the time when the matter is resolved. So our experience has been is that the Whistleblower House stands fastly once they've had an assessment, both an internal and external assessment of the prospects of success and also the merits of the inquiry, bearing in mind the disclosure made, perhaps also the employer party. So there are many factors which are taken into account. The evidence that would be presented is the evidence is the disclosure that was made, as well as any evidence which would have been related to or consequent to the occupational detriment. So a notice to attend a disciplinary hearing, maybe even the outcome of a disciplinary hearing, policies that may or may not have been in place. So that is the type of evidence that's presented. Although at trial, what we refer to as viva voce evidence, oral evidence, will be led. So there are risks, and I'll perhaps end off with that because it's a nice way to segue into our next speaker. But there are risks in making a protected disclosure. And I'll discuss the occupational detriments which one may suffer, but there are also risks in pursuing the claims. As much as we may vet a claim and prepare a claim and argue a claim, litigation is always a risky process. It's also very public, depending on the employer party and the nature of the disclosure. So there could be a public relations risk, could be a litigation risk. Then, of course, there are the financial risks that come into play. And then importantly, there's the emotional investment, both by the person making the disclosure and by those who provide that person with support. And I think I'll end off there, being my 15 minutes. But certainly, if there are any questions, I'll stay on the line. Thank you so much, Ben and Matthew.
Sianda, over to you to speak about the psychological support.
Thank you, Ben. I appreciate it. Good morning, everyone, and welcome to the webinar. I'm Sianda Msibi. I'm a board-certified counseling psychologist and also registered with the HPCSA. And I will be speaking through the psychological support portion of this webinar today. Most importantly, what to expect as you are going into this venture of therapy and seeking support. It can be quite an intimidating and uncertain process. And intimidating because a lot of the time people are unaware of what it is like to see a psychologist, have perhaps only heard certain information about what therapists do. There's a lot of misinformation out there about what the role of a therapist is and exactly what to expect. And hopefully today I'll be able to clarify with you what that looks like, and not just what to expect, but a bit of orientation about therapy and the process of therapy and what perhaps you might be introduced to. So the first part of any relationship in therapy is to introduce yourself to the person you're going to speak to. So often through the Whistleblower House, you'll be put in touch with a healthcare professional, someone like myself, or a different therapist. So although I am speaking to you in my own capacity today as Sianda, you might not see me as your therapist in particular, but you will be referred to someone in the psychological therapeutic capacity who will help you through the therapeutic process. So I'll be speaking in general about what the process is like, what to expect, and ultimately then when you have any questions, please feel free to hold on to those until the end of the session, make notes of them, and we'll clarify further. But when it comes to being introduced to a therapist, initially, once the Whistleblower House refers to someone, you can expect for the therapist to make contact with you first, so to introduce themselves. And essentially this comes through email, it can come through phone call if not everyone is in touch with emails or has access to being able to make contact. So this can come in form of a telephonic phone call as well, if that's what you prefer. Otherwise, generally, you'll receive an email to put you in touch with one of the healthcare professionals where they will introduce themselves to you and essentially start to schedule an appointment with you in this email and send what we call a consent form. And in this consent form, there's a lot more information for you about what to expect in therapy. Of course, I'll be laying that out now, but that's the first port of call. It's just an introduction to say who they are, where they're from, and that privately you'll be then keeping in touch with your therapist. A lot of information is very sensitive, so we do try to keep things very much one-on-one in our therapeutic capacity, just because there's a lot that's left to interpretation that can bring misinterpretation as well. So you'll be then introduced to your therapist privately, where they'll schedule an appointment with you. You'll be sent a consent form, and what you can expect in this consent form to read is about confidentiality, more about the therapist in terms of their modality, in terms of how they work, talk therapy versus other kinds of therapy like cognitive behavioral therapy, dialectical behavior therapy. These are just different types of talk therapy that you'll be introduced to. Please note that when you are introduced to a therapist, one size does not fit all. So please do not be concerned when, there's a lot of concern for, I don't relate to this particular kind of therapist, people feeling like they might not be able to understand or get their particular message across to a particular therapist. It is not a one size fits all, and sometimes there will be and I guess that's what a developing relationship is like with any kind of individual therapist. It takes time to get a feel for that particular therapist and for them to get to know you as well. So what I like to say in the beginning to my clients is, don't shoot it down the first time. Really get a sense for this therapist that you're going to be sitting with and getting to know, and get a sense for how they work and how you feel in the room with them, whether it's virtual or in person. So that's the other thing about therapy is therapists do offer both virtual and in-person sessions, depending on what you're comfortable with, depending on what is also possible as well. Not everyone can attend based on transport, fees, different meeting schedules, can afford to see their particular therapist in person. So please also don't be worried if you're not able to travel. There is a virtual option for therapy, with myself included in that. Okay. So as we're moving more into the consent of therapy, we're talking about what cancellations are like, emergency contact as well, particularly because in therapy, it's very difficult to speak about a lot of what has occurred that's led you to that particular point. And so we take into consideration the sensitivity of information, the nerves at which you're walking into the session with, your particular set of concerns as well. All of this we take into regard. And so what's really important is, in the session, there will be some very heavy and very sensitive emotions that both the individual is feeling, not just for themselves, but for the impact this has had on their family, on their support systems, their identity, who they think they are. And so we take this very seriously. And as these emotions well up, we like to be sure that there are individuals that we can contact if necessary, when there might be a need for additional psychiatric care or medication, depending on what is needed and what is necessary. So when it comes to particular instances regarding what exactly the therapeutic session then looks like once that initial contact has been made, essentially it's an orientation. So I like to orientate my clients to therapy. Essentially this encompasses getting them comfortable in the room, whether it's in person or even online. So when we talk about getting comfortable, we talk about creating a safe space where we speak about privacy and confidentiality, especially in these cases where information is very, very sensitive. Because of all the, he said, she said, how many charges have been laid against the individual. It's all very sensitive and quite intense. So when we talk about a safe space, we talk about confidentiality being that unless there is, so confidentiality essentially means privacy. So what you say in the room stays in that room, unless there are particular instances, unfortunately, where confidentiality cannot be reserved, but I'll get more into how then that's relayed, particularly when it comes to instances of being in court. Because I know that's also been a very big concern for a lot of my clients, is what happens if I have to go to court, and which is often very much a reality for whistleblowers. What happens when I'm in court and I've said all of this information to you, and perhaps they are asking to see you? In other words, I am then called to court, or one of the therapists are called to court to testify. What happens in these particular scenarios is, of course, what you say stays in the therapeutic room. What I say to my clients is that the law, unfortunately, is above me, but that doesn't mean that your information is not protected. What this essentially means is what you say in the room stays in the room. However, when it comes to being in the court scenario, the court is above me, and so no reports are written on therapy. That is an ethical obligation that all therapists have, is no reports are allowed to be written on therapy. So essentially, I am not ethically able to write word for word accounts about what was said in therapy. That's not ethical. However, sometimes we are subpoenaed to go into court to speak on the witness, as a witness on the facts. What this means is we essentially will speak on factual information. So are you in therapy? How long have you been in therapy for? How many sessions have you had? And what the therapist's clinical judgment is of your process. And what that means is, how has the person responded to therapy? If they can be given account on perhaps their state of being. And in that regard, your therapist will use their clinical judgment to ascertain what information is necessary to disclose. But before doing this, you will be asked to provide written consent before with your therapist. So your therapist and yourself will go through a session where you and your therapist discuss what the relevant information to be disclosed would be. And you would and this is very context specific, so it's very difficult to say in detail what can be said, what would be said, what exactly wouldn't be said, without seeing it case by case. So please keep that in mind as well as I'm discussing these very general specifics about what to expect in therapy, particularly when it comes to very sensitive information being disclosed in court proceedings or with HR or anything like that. So as I was saying, is your therapist and yourself will sit and discuss first what kind of information is relevant to disclose regarding what could be asked in court. So for instance, general things like how you've been doing, the impact of this entire case and the entire process being unfairly dismissed, what that impact has had on your mental and psychological well-being, as well as your health, and any additional kinds of impact this has had on you financially as well. So I'm just going to catch my train of thought for a second, because it's not as simply explained as there's a lot of detail. So essentially what would occur then is, once you have written consent and the therapist has written consent, at that point, when therapist is in court, they will then explain, based on what you've consented to, what the process has been like for you and the impact it's had on you. And of course, any kind of diagnostic sort of information might be relevant in that particular case. So if it was a need for diagnosis that might be relevant to your particular case, that might be information that may be helpful in disclosing. This is a double bind, however. So again, like I say, it's context specific. Yes. So that's with regards to the safe space and what that looks like in therapy and what to expect. Please know that, please write any additional questions that you have in the Q&A section, because there's a lot I'm not going to be able to cover specifically. In your therapy session, your therapist also does a history-taking interview with you. What this looks like is it's not going as far back as childhood, so much as it is gaining information about where things began to current. So in terms of where did everything start, who's involved. Sometimes I tend to like to keep the names of individuals out, again, for confidentiality reasons, for court specifics, etc., etc. So it is very dependent on what it is the particular individual is comfortable speaking about and disclosing. You are not forced to speak about anything that you're not comfortable speaking about, unless you are reassured that you will be covered. When I say covered, I mean there isn't complete confidentiality. Like I said, it's the law above myself. It's the law above all therapists, in fact. And so if we are subpoenaed, for instance, subpoenaed to come testify in court, or subpoenaed in terms of our notes, because therapists do write process notes with regards to how the session has gone, then we do need to, then that will also be discussed in therapy as well, with regards to what kinds of information will be, you would like to consent to being said. This can be very difficult as well. I can see I'm running out of time, so I'm just going to rush through things. I'm just going to go at a quicker pace as well. But this history-taking interview also involves just a culmination of what exactly has led to this particular has led you to therapy, but to this particular circumstance in your life, and also to chat about the layers of distress. So that's a very important component, is that this entire experience is not just stressful, it's quite distressing for both the individual and the family as well. And when we speak about distress and the distress in layers, we're really talking about the severe, intense kind of fight or flight mode that you are put in by virtue of having the rug pulled from under you, or your life shifting from, for instance, just being employed to not being employed at all. That's a massive adjustment in life that no one can tell you how to navigate without the additional support. So when we're talking about, we're not just talking about stress, we're talking about distress and how that impacts you both on a physical level, on a mental level, and emotionally as well. And then the by virtue, the subsequent ripple effect that has on the family and community. It's quite an isolating experience for anyone to go through, very uncertain, and quite frankly, incredibly scary when you think about what the process is going to be like, how long it's going to take, what this means for your future, etc., etc. I've just seen someone in the comments section ask about the fees, and we'll get to that momentarily as well. I think Cynthia might cover that in a second. So I'm just going to read this definition of stress quickly, just to help you understand what stress looks like and what to expect in terms of the symptoms you will be able to identify. So how do you know when you are experiencing unhealthy levels of stress? I'll read here. Stress becomes a problem when it lasts a long time, or if you feel overwhelmed and unable to cope with your situation. Stress becomes unhealthy when you are exhibiting physical symptoms that cannot be or are not explained by a medical occurrence or problem. I think that part is incredibly important to note when it comes to experiencing stress and trying to identify if you are experiencing anxiety or if you're experiencing what level of stress you're experiencing. Healthy levels of stress, which are actually genuinely healthy, are more motivating. They motivate us to get up, it motivates us to get going, to achieve, whereas excessive stress feels more debilitating, feels paralyzing, feels almost like you can't think. And so some of the symptoms that you can identify when it comes to experiencing excessive stress, distress, symptoms related to anxiety or depression are the following. So feeling incredibly withdrawn from friends and family, excessive worry, so not being able to shut your mind down because you're worried about what's going to happen, what has happened, what you wish you could have said, what you wish you didn't say, how you're going to provide, how the bills are going to be paid, etc., etc. So it's excessive worry about everything all the time and not being able to stop, feeling exhausted, shifts in your appetite. So it could be appetite increase, decrease in appetite, and this particularly is very much around your baseline patterns of sleep and appetite. So what you would know as a baseline for yourself, excessive appetite increase or decrease, you need to ascertain in that regard with the help of your therapist as well. Remember, this is all taking place in the history-taking interview as well, where your therapist is asking the relevant questions to help you ascertain if what you've have been experiencing is anything to worry about. Please also note that a lot of these symptoms, and I'll continue to read what the others are in a moment, are also, I'm going to say, common to experience when you are to feel and experience when you are going through a very distressing time in your life. Okay, so a lot of these symptoms are common. However, and this can be discussed further with your therapist as well, depending on the period of time you've been experiencing these symptoms for will then dictate the severity and urgency of the help you need. I hope that makes sense. So other symptoms will be things like headaches, muscle tension, upset stomach, changes in your mood, thoughts of self-harm as well as suicide. That's very, very common when it comes to these very detrimental cases of just the feeling of not knowing what to do. The helplessness and the hopelessness evokes thoughts of either death wishes, suicide, or even self-harm just because you wanted to stop. And so this is why it's important to have psychological assistance, a therapist who can help you navigate through this and also help you understand what is normal and what is cause for concern. Okay. I'm going to stop there for now and actually just leave it up to the Q&A section to ask whatever questions you would like to with regards to psychological assistance. And yeah, leave it up to that. I'm going to hand it over to Cynthia for now and await your questions. Thank you guys so much for your time.
Thank you, Sianda. Cynthia's having connection problems, so what I'm going to do is I'm going to swap the two topics around. Cynthia would have spoken about finance, and hopefully she can come online in a few minutes. And then I would have finished the discussion off with the security and safety. I just want to make an announcement. So we have appointed Solofelo, and she started to work with us at the beginning of August. Myself and Cynthia, for the last 2 years, have been shouldering the burden. At the moment, I think we have 317 whistleblowers that we're supporting. I think another 2 or 3 came through over the last day or two. Solofelo has been appointed specifically to support Cynthia in terms of whistleblowers. And it's important that we capacitate the Whistleblower House. I just want to answer 2 questions that in the comment section. The one is what stays in the room is a big challenge. That is why we need to improve the ethics culture first. Psychologists and lawyers are bound by very strong ethical rules. And if they speak out, they can in fact lose their license to do that. We have selected the psychologist very, very carefully. Cholofelo, you can put off your camera. I think people saw you. And the idea is that we've selected our psychologists very carefully because we understand that we are dealing with a very dangerous environment. People trust us with their lives, with their feelings, with their families. And therefore, we don't just bring people on board, people willy-nilly. We check them out. We have interviews with them, etc. Who is responsible for the payment? The Whistleblower House covers all the costs. So all 4 categories that have been mentioned, we in fact cover all the costs there. So when somebody approaches us, first thing you apply online. Let me start right there. First of all, you apply online. We make sure that you meet the definition of a whistleblower house in whistleblower as far as we're concerned. And we lean backwards to make sure that we can in fact support you, etc. We then allocate you to a lawyer on the panel, and we'll appoint you to the psychologist on our panel as well. And the idea is that we cover all the costs. Whistleblowers very seldom have finances lying around. They cannot afford these costs. And we were very lucky enough to get donors. And over the last 2 years, we've been very successful in raising funds. And we're comfortable that we will be able, the funds that we have available will last us until the end of next year. So we continuously find new funding so that we can do that. The next topic right now is security, safety and security. South Africa is a very dangerous environment. We're probably one of the top 10 most dangerous countries in the world. A whistleblower, and the names are very often in the newspapers, very sadly, and the one that we celebrated recently is Babita Deokaran. People are sitting in London, people flee the country, and we try to support them. Our mandate is very specifically, the board has given us a mandate to support whistleblowers within South Africa. Very important, within South Africa. And the reason for that is we've got to limit ourselves in terms of what we know. And we understand the laws of South Africa. So when somebody from Zimbabwe, other countries, etc., can't come through, we can't help them because we don't understand the legal system there. We don't have lawyers there, etc. We are trying to create networks in other countries so that we can actually fact address that. Um, can can somebody just put up a hand? You can hear me?
We can hear you, Ben. Yep.
Okay. Let me focus on security and safety. In many instances, when somebody comes forward, it is not foreign for somebody's life to be threatened, their children to be threatened, etc. So what we offer people is when you apply, you fill in your personal details, and then there are 4 categories that you need to choose from. The one is legal. Do you need legal, yes or no? And there are questionnaires to guide when we refer you to a legal firm, to guide them as opposed to the background, etc. But the first thing we do is to ensure that there is no conflict of interest. So when somebody, and I'm using ESCOM just as an example. So when a whistleblower from ESCOM contacts us, we've got to contact the panel to make sure that there is no conflict with a panel with ESCOM. If there isn't, we transfer you to them, and they then make contact with you and then discuss the way forward. Very important is that we as a whistleblower is not interested in the detail of the case, because whatever happened to you and with the case is between you and the lawyer. It's coincidental when we get to know things, and it's always the whistleblower always wants to share. So in many instances, people give us reams of documents. We can't do anything with it because we are not involved in the whistleblowing case. We don't do investigations. We don't do anything else. We refer you to a lawyer, and when required, the lawyer will contact us to say, is this okay, etc. But the case itself, we don't get involved in. That is the lawyer's job. Psychological. The psychologists that we have on board have psychiatrists that they work with, and something Sianda may just respond to later. Our panel have relationship with psychiatrists. So you can't just walk into a psychiatrist's office and say, I need help. You need to work through a psychologist, and they refer you, medication, do you get admitted to an institution, etc. That relationship is sacrosanct as well. So information is not shared with us unless, and there are two scenarios here is, number one, do you need additional help, additional sessions? Because we allocate 10 sessions. When we refer somebody to a psychologist, 10 sessions is immediately covered. But sometimes people need more, and we allow that. 15 sessions, 20 sessions. Sometimes children need help, the spouse need help, the partner need help, and that is also covered. So we try to minimize the cost. I mean, we take away the cost completely, so not minimizing it, but we try to help the whistleblower as far as we can. Security. We have, when you tick the box for security, what we will do is we'll get a specialist to call you. And sometimes we find that the whistleblower do not take the calls. So whistleblower X comes through and say, I need security. We pass you on to the security company, and they now need to interview to find out exactly what are your concerns. Are you being followed? Which vehicles are being followed? How many vehicles? Were they breaking in your house? Do you think that your equipment has been infiltrated? Those kind of questions. And based on the question, on the answers, a plan will be formed to make sure that you're safe. For example, one of the things that we've done is that we've partnered with an organization called Aura, and we have a whistleblower panic button, which you load onto your phone, and we provide it for you. We cover the cost. And when you press the button, you could get either security, depending on whether you need security and you feel threatened. And the second one is help, ambulance, if you're in an accident, anything like that, anything health related. So the two categories in the Aura app is, and you press the button, and the closest security or ambulance service. So it's not only Springbok or a particular security company that's been contracted. All the security companies have been contracted. So the closest vehicle to you will then be sent out to you, and your location on is your phone is being used for the location period there. The questions that's popping up is, do we have safe houses? No. The problem with Safe House is you can only use it once, because once you've used it once, you cannot use that again, because the news gets out there. One of the challenges we have with whistleblowers is that they publicize where they are. I'm at the restaurant. I'm celebrating 21st birthday. I'm doing this, and I am in a restaurant. So they're putting out on Facebook, and they expose themselves. You should not be doing that. We try desperately to tell people, when you're in the process, please be quiet. Don't invite attacks. Don't invite unnecessary attention, etc. But it's difficult because whistleblowers want to talk. They are suffering. They want to share their pain and anger. So what we do is we will, and there are whistleblowers that talk about the services they've received from us. I won't mention the names. We've had somebody for a month out of the country. We supported them. We have people in Ireland at the moment whom we support financially, etc. So what we try to do is to make sure that each individual case is handled individually, is tailor-made for them, etc. We also find that psychologically people are affected. And so therefore that is important to do as well. And people become paranoid. It's normal. There's nothing wrong with being paranoia. With paranoia. That is dealt with separately. But we must make sure that the threat against you is real, and then we act accordingly. So number one, you get the Aura app, no cost to you. So you can have a panic button. We look at people's homes if you need an alarm system, and we try to help you there. But with the Aura app, that becomes unnecessary. When you need, we even helped whistleblowers move from home when they had to consult either a lawyer or a doctor, and they feel threatened. We provide them with they are taken there by with close protection officers to and from. So that is what we try to do. I don't want to share too much about the security stuff, because that is a case-by-case matter. What we do is to make sure that we understand your particular needs, and then we address it accordingly. I may not get the chance to speak later. I'm to wrap up on this portion, and I see Cynthia's online so she can talk about the finances. What we have done is we've developed a how-to booklet for all 4 categories. And it's written, it's now being language checked, it's being bound properly, etc. And that will be published on our website. So when you want to know a little bit more about security, there is something that speaks to security. When you think you want to blow the whistle, what are the things you need to look out for? Now, this is not an encyclopedia that says, if I follow this, I can do X, Y, and Z. Contact us. The booklets are there to guide you, but contact us. Spread the word and say to people, please, before you do anything, contact the Whistleblower House. They have professionals on the books. They will assist you, and we will do everything we can to actually achieve that. I've spoken on the security. Let me hand over to Cynthia, and she can then talk about the stipend that we provide. Very limited funds. Our money is very limited. We are dependent on donors, and we try to stretch our money as far as possible. Cynthia, over to you.
Morning, everyone, and thank you, Ben, and thank you, our host, for having us up on this webinar. Just apologies, I was having connectivity problems. Thank you. So regarding the finance, we provide a financial stipend for our whistleblowers when they are in need. We obviously cannot replace the salaries of whistleblowers. We know the dire straits that they go through when they lose their jobs, and then more difficulties arise when they cannot find jobs. So their livelihoods are gone. They lose their homes, their assets that they've built up over the years. And we do understand the tragedy of this. So we, in our mandate, have offered a finance support system for whistleblowers. At present, for this year and last year, we've got board approved for 90,000 Rand over 6 months, meaning 15,000 Rand per month. However, there is forms to be completed, bank statements to be submitted, and for us to do a full evaluation and review before the client gets that. The clients need to sign the forms, and B, they need to also provide certified IDs. Reason for that, we're working with donor funds who we need to be accountable for, and we need to be audited, and we need to give evidence that we have paid these funds to bona fide whistleblowers. So what we do know is that we cover, for instance, we're able to cover your school fees for children, obviously not private school fees. If your child is at a very good Curo, Hilton, one of those private schools, we cannot cover those fees, obviously. So the amounts is to pay for the schools that the kids can go to, the public schools, put food on the table, pay for your airtime, petrol in your car, so you can get to those interviews that you need to get through. And the main purpose there is to just get your dignity back as you try and find work or try to build yourself from where you are. We have had challenges where people would want us to pay more than that. Can we pay for their cars, or can we pay their outstanding mortgage fees? Unfortunately, it's something we cannot do. We hope that next year, through obtaining additional funding, we could probably increase the stipend, which we hope as we go along, as we seek funding. But we cannot, unfortunately, pay the entire costs of the whistleblowers. So we've also partnered with organizations. I saw a question with PLAF, who we would assist with counseling. As Ben mentioned earlier, we will assist with counseling, but and possibly finance for those clients, again, on the same basis we do it for our own clients in South Africa, and that are clients to the Whistleblower House. And the main purpose there is so that you can just tide you over. It cannot replace the salary, which we know. We've looking at options of how do we as Whistleblower House, provide certain skills so you can get back into the workforce, create employment for yourselves. So we've partnered with a company called Tau HR, which is with Douglas Armstrong, and hopefully we can then start working with that to try and get whistleblowers CVs out, whereby you are coached on how to talk about your whistleblower experience, that it doesn't appear as a negative experience. And that hopefully will help you then start earning for your own income to get your dignity back. So in a nutshell, what we do for whistleblowers is on the financial aspect. We have a form that you need to complete. You need to provide your certified ID. You need to provide 3 months bank statement and a form which is net assets that you have. You should not be earning more than 20,000. If you do, we're unable to provide the finance for you. And if your net assets are more than 500,000, we also will be unable to provide the stipend for you. If there's any questions, we have a Q&A and you can put it in the chat. Thank you very much. Thanks. I see one of the questions. Do you provide recruitment services for whistleblowers who have suffered occupational detriments? There must be a goal to assist whistleblowers to be absorbed in the labor market, especially in the public sector. Yes, thank you for your question. It is an excellent question. It is one of the challenges we picked up while working with whistleblowers since 2022, and hence the reason we've partnered with a company called Tau HR, Human Resources. The gentleman is Douglas Armstrong. You're welcome to email us and we will put you in touch with Douglas. He's also a life coach. So what he does is assist you with rewriting your CV, firstly in a way that you bring out the fact that you whistleblower, but he coaches it in such a way that it's in a positive way, because most organizations see it as a stigma in a negative light and therefore do not hire any whistleblowers. And so he'll put you through some coaching sessions, and then he will then put your CV out to various of his contacts. He's been able to employ 2 of our whistleblowers, or got them employed. And for 2 others, he's coached them when they went for their own interviews, and these were able to get positions at those particular organizations. So yes, it's part of the work we're doing currently. Thank you for the question.
Another question asked is, do we actively feed the cases to the SAU for civil recovery? No, we don't. We are trying to build a relationship with law enforcement agencies such as the SIU, the Hawks, MPA, South African Revenue Services, but we don't refer cases to them. What we do is provide you access to lawyers and the law, because there are different legislation pieces covering different areas. The South African Defence Force is completely separate to any other whistleblowing environment. So it's important that you have that. And then you can make a protected disclosure under the guidance of the legal firms that we have.
Lapelo Kamani, you mentioned the stipend is only available to Whistleblower House clients. Will you assist whistleblowers who reported their disclosure to companies running whistleblower services? So we don't do any the whistleblowing online hotline services, so no, but you can come to us. So if you go to our website, www.whistleblowerhouse.org, you can apply and put your application there. Obviously, if you will, it will be assessed, and through that we will be able to evaluate whether we qualify for the stipend. I hope that answers your question, sir. There's a second question by Yasmin Bakkes. Would you consider making a presentation to the new Minister of Public Service and Administration to bring him on board, particularly when you have policy inputs and recommendations insofar as the protection of the careers of public servants? Ben, would you like to answer that one?
Absolutely. We have a relationship with the Public Service Commission, and we are talking to them. We are willing to talk to anybody. We've met with the previous Minister of Justice while we were in discussions with the evolution of the legislation. Unfortunately, he's been moved out, and there's a new one. We are waiting for the publication of the discussion paper. We have no idea where we are with that, etc. But we are willing, and we need to talk to companies, we need to talk to government, we need to talk to anybody who has people working for them to understand the importance of whistleblowing to safeguard the assets of South Africa and the people of South Africa. For too long, people have gotten away with too much.
Thank you for answering that, Ben. Yes, we've been doing a lot of advocacy work, speaking at various forums to raise this issue and to create the awareness. There is another question that says, do we you did answer the actively feeding into SRU? No. Do you assist with ensuring that a whistleblower, I'm just trying to see, ensuring that a whistleblower is put under protection by the NPA? So the witness protection works differently to the assistance we provide whistleblowers and a safety measure for whistleblowers. One is that the witness protection, pardon, you have to apply to them, and you are literally taken out of circulation. They put you in a safe house, which could be anywhere in the country. You lose contact with your family and friends. Your cell phone is removed. Your laptop is removed. Some people even have to change names and IDs. So we do not work or partner or collaborate with the NPA in this manner at all. If whistleblowers come to us and they require some safety mechanism, we look at short-term mechanism. As Ben has mentioned earlier, we provide the Aura app, which is like a panic button, as explained, that should people be following you, should you be concerned somebody is monitoring your home, you can call an armed response that will come out. The second type of security we offer is for those who need to go to court or require an armed escort to the court, or for safety, we will provide that. The third type, which we have provided to 1 or 2 people, is that they needed to stay in a safe place, and so we put them up in a bed and breakfast where there was high security, and we'd pay for that cost so that they just safe for a while until the threat has been minimized, and then they can go back home. But we don't work the same as the NBA in the witness protection. Thank you. I hope that answers your question. There's another question come up. Would you follow up with a KZN Premier who has been presented with a disclosure? Ben, may I hand that over to you, please?
We do. We stated this. I stated this previously. We do not get involved in the whistleblowing process itself. There's a process that's outside what we're involved in. Your lawyers need to do that, etc. So we don't get involved. We support the whistleblower and the family. The case itself gets handled separately and outside our jurisdiction. The lawyers would typically follow up on those kind of things. Svi, there's a question for you. Good faith?
Yes, perhaps I can answer that. I saw it came up a number of times while I was making the presentation, how the element of good faith has been removed in certain jurisdictions. And it does speak to the dichotomy that I referred to, which is making provision for some sort of financial gain for the whistleblower, weighing that up against the element of good faith. So there is an argument to be made that if somebody is making a disclosure for the purposes of a gain, in other words, a percentage of the amount of money saved, recovered, whatever the case may be, that it's not necessarily done in good faith. And that's why in some of those jurisdictions it has been removed. In our jurisdiction, because we don't make a provision for an element of sharing in the saving or recovery, that element of good faith has remained. But again, I know that representations have been made to develop the law, including some provision for financial compensation or gain directly from the disclosure made. And that is something that can be considered going forward. Thank you.
Thank you very much, Svi. There are more questions which I'll take now. From Nobula Mbutulezi, how long do you assist the whistleblower? Is there a time frame for the matter to be finalized so that it doesn't exhaust the allocated funds? Nambula, thank you for your question, and it's something that we're also considering as the Whistleblower House. So we have whistleblowers who started with us when we opened our doors and launched on the 22nd of February 2022. Their cases came, and it remains, because when there's a legal court case, we have to wait until that court case plays out. There are other matters where they can be resolved quickly, which we have assisted with people who have made a protected disclosure. We were able to get their pension funds. We were able to assist with all the, like getting a UIF, removing any charges from them, and then the matter can be closed, except if they're still doing counseling with us. Some matters we've closed when they're not pure whistleblowing issues. They're probably a grievance and non-related to making a protected disclosure, so those matters closed. But when a client has come to us and many have taken the finance, counseling, and the legal, only a few have taken security, so will stay with the app, or those that have had their assistance through either the housing or I would say the bed and breakfast, that matter would be closed. So yes, it's as long as the legal matter continues, we would still assist. Thank you. There was another question that I saw had disappeared. Okay. That was Nambula.
Somebody asked, can you please provide the citation of the Donnell case? Will you make that available? Not now. We can always email it afterwards to the panel, to people that attended.
Last one from Christian Powery. Just to clarify, the Whistleblower House is not a whistleblowing line. The whistleblower should still blow the whistle on the company's line. I see Ben did answer that. We would encourage you to make a full protected disclosure and rather do it safely through one of our legal panels. So if you haven't yet blown the whistle, rather come to the Whistleblower House first. We will refer you to the lawyers who will then make sure that your whistleblowing is a protected disclosure, and they will give you all the guidance. When you do it on your hotline, there could be someone there who could compromise you, or someone is already compromised who ends up with the data. An example, recently someone blew the whistle on the Transnet hotline, and that there were people who got hold of the information, who monitor the hotline, and someone else was assassinated because they mistook this gentleman for the person who blew the whistle on the hotline. And he was only 37 years old, and he was shot in his car while coming in through the gates of the organization of Transnet in Vereniging. So we would say, for your own safety, rather do it where you can do a proper disclosure through our legal panel. Thank you.
We're about to start wrapping up. It's 11:15. I just want to share some information. Don't stop asking questions. We can come back to that again. Cynthia, in an effort to raise funds and awareness of what whistleblowers go through, Cynthia have agreed to embark on a Camino. Camino is a long walk. And she will be doing the Camino, in the Cape Camino, from, I think, the 4th of October or the beginning of October to until 5 weeks. And it's called Walk for Whistleblowers. There is a link on our website where you can donate. Please consider donating. It is for a good cause. All our money goes towards whistleblowers. So please consider that, spread the word. Where anybody can afford to support us, please go there and press the link and donate.
Thank you for that, Ben. I truly appreciate it. It's literally R1 per kilometer. I'm walking 700 kilometers over 40 days, making it 6 weeks. And the symbolism I'm using is that it's 40 days when you're fasting. Most religions use that, whether it's Ramadan or the Lent for the Christians. And then there's 40 days when someone has passed away, after 40 days, you give a memorial. And it's also 40 days to change a habit, to make it a good habit. And then I'm carrying my own backpack. I'm not sending it via anyone to transport it, because it's the burdens that whistleblowers carry. You who are whistleblowers on this group will know how hard it has been, this journey of whistleblowing. And that's what I'm going to be advertising and representing. Every day I'm going to showcase a whistleblower story. So if you'd like us to showcase your story, please write to us via our info@Whistleblower House or contact us on our website. I'm happy to do it. I've already started contacting a few people. And it's only R1 per kilometer, and those who can afford it will be able to. I know it's very hard for whistleblowers because they don't earn anything, and for every cent they make, it's really hard earned. Just to give you an indication, I just did a calculation of our funds for our donors. Since we opened our doors, we've spent over 9 million just on whistleblowers. 9 million. And that's only 2.5 years. So our costs as our staff are very low. We don't have offices. We don't have cars that the company needs to pay for. Very low compared to what we paying to service our whistleblowers. And that is our main goal, is to help you, to give your dignity back as whistleblowers. Thank you.
Twee, any closing remarks from your side?
Thank you so much. Here we go. Thank you so much. Just to say thank you for inviting me to the webinar. I hope it's been informative for all of the attendees. Please encourage people to send in questions and inquiries, as we've seen on the chat, because I think there's a lot of misinformation out there with regards to how to go about blowing the whistle. And I think that there's a lot that we can do together. And finally, just to wish Cynthia good luck on her walk. Thank you once again, and enjoy the rest of the day.
Please remember to press the button and donate.
Absolutely.
Sianda, anything from your side?
Nothing from my side, but just to say thank you so much for this wonderful webinar. And again, just to reiterate, please send through any additional questions that you may have specific to psychological services, and I'll be happy to answer any of those questions. Thank you so much, and good luck, Cynthia.
Thank you, everybody. I think we've answered all the questions. I don't see any new questions. Thank you. We try to do the webinars once every 3 months. Be on the lookout for that. We try to be as useful as possible. We're trying to get the message out to as many people as possible, and we're trying to build the network. Thank you for attending. I hope it was worth your while. I hope you learned something. My apologies for the shaky desk. You can see we're working off a skeleton, so I can't afford to buy a real desk. Thank you, everybody, and goodbye.